Mr. Sharp, I want to make sure that you understand and know that I receive, the district attorney's office receives, your attorney will receive all of your disciplinary incident reports from the jail. I have 11 pages of them. Mr. Williams?
The charges are all the same in each case, Judge.
Yeah, I got to go through them. Okay. In cause number 22-40823, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that correct? And in cause number 22-41018, I also have a first amended motion to revoke your community supervision. Again, also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. And again, that was a 2-year sentence that was probated for 5 years, correct? And then cause number 22-41019, also have a first amended motion to revoke your community supervision. Also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that also correct? Speak up, please. Thank you. All 3 of these motions allege that you violated your probation. Count 1 alleges in each case that you failed to report as directed to the probation department December of 2024 and January of 2025. And is that true or not true?
True or not true?
Count 2 in each case alleges that you failed to provide verification of completing the theft program or the theft prevention class. Is that true or not true? Count 3 in each case alleges that you did not provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true?
MRT program.
MRT. True.
That's what we're talking about.
Count 4 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 in each of these cases freely and voluntarily? And did you plead true because all of those counts are actually true?
True.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign those, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case?
Objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in each of your cases, I'm going to find that you enter your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 22-40823, revoke that probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 22-41018. Find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-41019, find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. When you entered your pleas in these cases, I went over with you the fact that you're ineligible under Texas law to possess a firearm or ammunition. I'm attaching a copy of that because of the judgments. You are ineligible to possess a firearm or ammunition, and if you have questions about that, you can read that document or talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Morning, sir. Are you Luther Sharp?
Yes, ma'am.
Mr. Vasquez, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sharp, in cause number 25, wait, are we going on count one?
Count one, Your Honor.
All right, hold on. Let me get that done. Okay, in 25 DCCR 0916, the state has elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 15 years in prison, you can't appeal that. I can give you 15, I can give you less. It'll all be determined on the evidence and information that I receive at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and do 2 things. The first is to determine if you're guilty or not. And then the second is, if they find you guilty, then you could leave your punishment up to them. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
Also, part of that agreement is that the state would dismiss cause number 25. Y'all wrote C, but I think you meant DCCR.
That's correct, Judge.
DCCR 0917. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing, and so the probation department can do a pre-sentence report. We'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Vasquez, and he'll present it to me on your behalf when we come back.
Yes, ma'am.
All right, you can go back with the bailiff.
Your Honor, can I speak?
Sure.
Would the court consider a bond reduction?
Not with a cap of 15 years in prison. No. You can go back with the bailiff. Mr. Sharp, I want to make sure that you understand and know that I receive, the district attorney's office receives, your attorney will receive all of your disciplinary incident reports from the jail. I have 11 pages of them.
Yes, ma'am.
So if you think you're going to come in and ask me for any type of consideration on that plea, my suggestion is between now and when you come back, I don't have any more added to this.
Yes, ma'am.
I don't have to take the 15 years.
Yes, ma'am.
We could go to trial and you could get worse.
Yes, ma'am.
A jury will see all of this.
Yes, ma'am.
You're too old for this nonsense.
Yes, ma'am.
All right, go back with the bailiff. All right, are you Robert Lowe?
Yes, ma'am.
And so Mr. Lowe was previously in court, entered pleas of guilty to 3 cases of possession of child pornography. There was an agreement in those 3 cases for a 7-year deferred probation and a $1,000 fine, with dismissals, I think, in 3 or 4 other cases. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
I feel like this is different from some of these types of cases, because Mr. Lowe was actually involved in creating with his own family member victim who was very young, 5 years old. So this wasn't I downloaded something and didn't realize what I was downloading. This is very different. This is a family member that was victimized because of this. Don't talk right now, okay? And so for those reasons, I do not feel comfortable accepting deferred probations in these cases. So I'm going to reject those plea offers. I don't know, honestly, I haven't thought more about what I would be amenable to other than potentially just letting a jury decide. I'll reset it one time. You guys negotiate, see where you are on it. And if you come up with something, you can contact me. Otherwise, we'll get rejections and get his cases set for trial and let a jury decide one way or the other. Okay? I'm just not comfortable with this at all. You can go back with the bailiff.
But I already signed for probation.
I don't have to accept your probation.
I wasn't told that.
Yeah, you actually were, because we reset your case for sentencing. And here's the thing. It doesn't matter if you were or not. I'm not accepting the plea agreements. Okay? There's nothing you can do at this point other than Ms. Holmes will be out there to visit with you about any other options. And if you don't like those options, or if I don't like those options, then ultimately that's what a jury is for. If everyone can't agree, and then we get a jury to come in and determine if you're guilty and what the punishment is if you are found guilty. Okay? So let's see where we're. I'm not going to consider any bonds at this time.
Yes, Your Honor. I just, his mother is here, and so, but just for the record, because I have spoken with her on several occasions, as well as with Mr. Lowe. They did keep asking me if he would get out today, and my response to both of them was that it's up to the judge at the end of the day. So
Thank you, Ms.
I told you
Holmes.
that yesterday
Yes, ma'am.
when I visited with you.
Yes, ma'am.
And I told that to your mother.
Yes,
That
ma'am.
ultimately it's up to the court on whether you would be released today and placed on probation.
Yes, ma'am.
Thank you, Ms. Holmes. You can go back with the bailiff.
I can't say that else.
It's probably not wise right now. Okay? Go back with the bailiff.